Hi, this is Frank Stallone, and welcome to All Things PI with your host, Scott Ross.
And good morning. It is Thursday. I don't even know what the date is, July 19th. Joining us today is, and I really appreciate his volunteering his time, we have David Rudolph. He's the attorney, unfortunately probably better known for the current Netflix show called The Staircase. And in investigating and looking back at David's career, he's had some pretty significant cases that deserve a lot more attention than Michael Peterson's case, although that in and of itself is fascinating. David, you with us this morning?
Here, and you're a little bit faint, so
yeah, you're kind of breaking up, unfortunately. I don't know if you can find a better spot, but
let me see if I can find a better spot. Hold on.
Okay. Several of the other cases, though, while you're looking for that location, I wanted to talk about some of the other cases, Alan Gell and Floyd Brown, and it appears that you seem to have a specialty, which I can appreciate, in reversing verdicts and dealing with people, helping people, Keenan Gay, people that have been charged and convicted erroneously. Michael Peterson being one of those, although Michael Peterson was forced, and I understand why I've had cases in the past that are very similar, was forced to take a deal just simply because of logistics, financial. There's only so much you can put your family through. Have you found a better location yet?
There
you go.
I'm looking. Is this working any better?
Perfect. Stay right there.
Okay, I'm here.
So again, if you want to start with the staircase, start with Michael Peterson's case. Interestingly, I know that and again, when I say I know, I just from my own experience, that these types of cases can become incredibly costly, and it's not an issue of how much money Mr. Peterson has. You're dealing with the system that has what everybody lovingly calls deficit spending, and the prosecution can kind of run amok and run out of control. This was done for financial purposes to assist Mr. Peterson in his case, if I'm not mistaken.
Are you talking about the staircase itself?
Yeah, the production company filming The Staircase.
No, that's not accurate. They came to us early on in the case. We had just started working on it. They were referred to us by Court TV, which had covered the trial of Ray Caruth, where I represented Mr. Caruth in a murder case.
Right.
And they were actually just calling to ask if I knew of any cases that they might be able to follow. They were interested in following a case that did not involve an indigent defendant. So at the time, I said, well, I'm just starting to work on this. I didn't realize they wanted to do a documentary that involved real-time recording of what was going on. And so they came and talked with us, and we eventually agreed. But neither Michael nor myself have received a penny at any time from documentary filmmakers or anyone else. That was not the purpose at all.
Oh, my mistake. I was involved in a very high-profile case where the defendant did not have a lot of money and agreed to be videotaped, and they did a similar situation. But because it hasn't concluded, it has not been aired yet. And again, he just simply didn't have the money to combat or to defend himself what was considered to be properly. And so he did that. I assumed it was sort of a similar situation, but
it was purely from Michael's perspective. It was purely because he felt like he would not get a fair trial in Durham, and he felt like having a well-respected outside documentary filmmaker involved would level the playing field somewhat. And from my perspective, I really felt like it was important for people to have a much better sense of what criminal defense lawyers actually do, as opposed to how we are portrayed in popular culture movies, TVs, and that sort of thing. So I agreed to do it, really to try to educate people about what criminal defense lawyers do in a murder case.
Yeah, and in fact, I have referred to it now. And again, I know that Ron Jarrett has since passed away, and I'm, again, very, very sorry about that. But when now people ask me what I do, my response is watch The Staircase, because it's the easiest way to sort of define what we do. Ron, again, I am guessing Ron had probably a significantly larger role than was portrayed. But
oh yeah, I will just say that Ron was integral to everything that I was able to do in the courtroom.
Right.
And people who don't understand the role of a good criminal investigator really are missing a big part of what goes into presenting a defense, because I could not begin to do what I do in the courtroom without Ron's work outside the courtroom.
Yeah, and you know, again, it was nice to see your relationship with him is, again, similar to that of mine and Tom Mesereau or Harlan Braun or Carl Douglas, people that I have long-term relationships with. And I enjoyed watching Ron's work simply because I know I sort of know what's going on. And when I watch your story unfold, when I watch you put on the case, again, I am fully aware that Ron had a significant role in making sure that all of the information that you had was there. The one question I really need to ask and I really want people to watch the show, The Staircase. It really is absolutely fabulous, and I have told everybody I run into. But I'm trying to I was talking to friends about other work that you have done. And there's another case, Alan Gell, who was also wrongfully convicted and subsequently got a monster verdict against the same agency, Dwight Ransom, who was also an investigator, along with this Dwayne Deaver, who lied about information, who misrepresented information, who manipulated tests. How do these people not get criminally prosecuted?
Well, as you know, criminal prosecutions are up to the district attorney's office, and indeed there was another case, Floyd Brown, involving an SBI agent,
right,
where he fabricated a confession. We ended up getting Floyd $9.5 million. He spent 13 years in a mental institution because he wasn't even competent to stand trial. The bottom line is that the best we can do right now is to extract monetary punishment. And it really isn't punishment for the agent. It's punishment not even for the SBI, because at the end of the day, it's insurance companies that cover that. But hopefully that brings some light and some pressure on the agency to then discipline the agents, and at some point perhaps prosecutors will actually start prosecuting these cases. Now, interestingly enough, they have begun prosecuting some of these police shooting cases, and that's a real change. In years past, no police officer ever got charged for a wrongful shooting. So that's beginning to change, and perhaps some of these experts and agents who fabricate evidence will begin to be charged. But right now, that's just not happening.
And that's an issue that's going on in Los Angeles County. Our DA, Jackie Lacey, just will absolutely not charge a police officer, and it's all about getting reelected and getting votes. And it's criminal in and of itself. But to sit there and misrepresent your experience, and again, part of the show where Ron gets up and did his own investigation as to Dwayne Deaver's expertise and how he misrepresented, I'm surprised that the judge himself didn't prefer charges. I also want to talk to you. We have to take a quick break, but stick around, because I also want to talk to you. I was kind of interested in how they managed to go to a grand jury, and I want to talk about the difference between a grand jury and a complaint when we come back. So is All Things PI, and we're going to be right back.
Talk Radio, KCAA 1050 AM.
Are you having trouble sleeping? Are you always tired and worn out? Is it affecting your work and personal life? Well, South Pacific Sleep Lab can help you out. South Pacific Sleep Lab provides a personal study of your sleep patterns. With their trained specialists, they will diagnose your sleep habits and will give you a prognosis for getting a great relaxing night of sleep. South Pacific Sleep Lab has locations throughout Southern California, including Fontana, and will provide transportation to any of their locations at no cost to you. To find out more, give them a call at 844-SAD-5050. That's 844-SAD-5050. South Pacific Sleep Lab. Start resting easy and sleeping sound today.
Hi, my name is Phil Grandy, philsgang.com. Most people would love to be in the stock market, but they're scared not being in. They're scared about not getting out in time. Well, that is over, because now you can join Phil's Gang and my stock video program and follow me with a specific stock on the video, and you will be out in time.
Find out more at philsgang.com or call 877-600-GANG. That's 877-600-4264. Why pay thousands of dollars for a weekend seminar when for only $39.95 a month? philsgang.com provides all the daily market investing information you need to make profits in the stock market. With over 40 years of investing experience, only Phil Grandy and the philsgang.com team provide daily live investing webinars, up-to-the-minute market updates, all the investing educational videos you can imagine. Don't hesitate to learn, invest, and make profits. Go to philsgang.com or call 877-600-GANG, 877-600-4264.
Bye-bye, sailor. No more sailing.
Okay, David, I'm sorry. We had to take a break. We are back. But one of the things that I saw in the special, they went to a grand jury within, 7 days. Is that normal for North Carolina?
It is normal. I know it's very different out in California. You have all these hearings before you even get to the grand jury. And I only wish we had that in North Carolina, but we don't. So it's not at all uncommon for them to go directly to a grand jury. 7 days might be a little bit faster than usual, but there was nothing particularly strange about them just going directly to the grand jury.
We have preliminary hearings. The only time they really go to a grand jury is when they have multiple defendants, and it's going to take 3-4 weeks for a prelim. So yeah, typically, and from our standpoint, from my position, having a preliminary hearing is advantageous because you get 2 bites at the apple.
Absolutely.
Yeah, when you go to a grand jury.
We try very hard to get evidentiary hearings on pretrial motions, which we ended up doing in the staircase.
Right.
But obviously, having a full-blown, and my understanding is you guys do very, very lengthy, sometimes preliminary hearings, is just a gift for a defendant.
Yeah, having watched that, I guess I didn't realize the value of it, which I clearly do now. It is a gift because I have had many cases dismissed after a prelim that the prosecution just couldn't prove their case, and we have had a significant amount where, the old adage. Go ahead.
I was going to say, and it's in some ways a gift for the prosecution because they get to see the weaknesses in their case before they expend enormous amounts of resources on it. So I think it serves a purpose for them as well, just in helping them separate the wheat from the chaff in terms of what cases are going to be going forward.
And that was interesting too in the staircase to watch the experts that you brought in, Henry Lee, and those are not inexpensive experts. And it's sort of sad because then it turns it into a financial issue that you have to be able to afford to hire the best. You have to be able to afford to hire people that can actually help or assist in your case, where the prosecution brings in, anybody they want. They write bad checks that some bank will cash. Again, deficit spending.
Well, and not only that, but then you get bashed over the head for bringing in really world-class experts. I mean, every expert we had in that case was chosen not because of what he or she had to say, but because of their expertise and their background.
Right.
And in closing argument, what we get back is, they brought in all these high-priced experts. We just have been good old Dwayne Beaver. He's tried and true. He's one of us. And so you get a little hometown cooking over your experts as well.
Yeah, and again, that's true. When you get to a position where you've got that expertise, when you've been working as long as you have, again, it's one of these things that people have always been reluctant to call Tom or Harlan Braun, simply because they think that you've worked on such large, high-profile cases, whatever, that you're incredibly expensive, and that's not always true. Tom does a lot of pro bono work down in the South, and that sort of, keeps that reputation alive. But you seem to have developed a niche for reversing verdicts. I think that's kind of interesting. You're not really an appellate attorney, are you?
Well, no, it's actually, I generally tend to get involved in those cases after the conviction has been flipped. The niche have sort of developed over the last, really, since Alan Gell's case, so over the last 10 or 12 years, is to do wrongful conviction 1983 civil rights lawsuits. And so I've done maybe 6 or 7 now over the last 10 years. And they're fascinating for me because it's sort of like doing an autopsy of the prosecution. Only I know, just from having done this for so long, I know exactly when the police are cheating, why they're cheating, what their motivations are. So, when I get one of these cases referred to me, I have a real advantage over sort of somebody who's just done civil work their whole career, or somebody who even has done civil rights work solely over their whole career, because I've done criminal defense work. I've been in the trenches. I've done those cases. And so I just know, instinctively where the body's buried. And I've really enjoyed doing that, because all of a sudden now I'm in the role of sort of a quasi-prosecutor, proving the misconduct of the police. And that's just a really nice place for me to be towards the end of my career. And so it's been really rewarding for me, just to be able to be in that position.
Yeah, it's ironically and interestingly, it's sort of empowering to be able to the civil suit that you're talking about. It sort of re-ups the advantage, because now you have subpoena power. And one of the things that I thought was fascinating, that in Michael Peterson's case, he was convicted and sentenced within, by parents, it looked like within 20 seconds, which is fascinating because, again, in California, you still have subpoena power up until the sentencing. And again, you file a motion for a new trial. You can ask the judge to sort of not necessarily reverse the verdict, but take a look at the policies and procedures and things that he did, where clearly in your case, Judge Hudson went back and reviewed his some of his rulings, and down the road regretted them. But in the same respect, to see somebody sentenced right there on the spot, that's also normal for North Carolina?
That is absolutely normal. I mean, there's no pre-sentence report. There's no chance to do any kind of pre-sentence memorandum. Now, of course, in Michael's case, there was no discretion. The judge had to give him life without parole, given what he was convicted of. But even in cases where there is discretion, it is very rare in North Carolina for sentencing not to immediately follow the verdict.
Interesting. Yeah, again, even, for example, like with Cosby, that obviously we worked on, that I worked on, Cosby's sentencing is being put over until September because, again, there's a motion for a new trial, and then there's mitigating circumstances. Yep. And, so it's very, very common. And to sit there and watch that. And again, I acknowledge I do not know North Carolina procedures. But I was very, very surprised by that, as well as the as well as the indictment. One of the things that I was really excited about when I heard you talking about is Scottish law. You were talking about the guilty, not guilty, and not proven, which is something that I've been an advocate for years. You and I both know it'll never be used in the United States, but again, this was too much of an emotional case, Mr. Peterson. So I can't see it being done that way. But in Gell's case, it's interesting because, correct me if I'm wrong, didn't the victim's son actually believe that he was not guilty?
Yes, although I can't remember, to be honest, whether that only was in hindsight after the verdict. What came out in the Gale case was that there were something like 18 people who had seen the victim alive at a time after which Alan Gale had been in prison, arrested and locked up for a somewhat minor crime. So if those people were accurate, then Alan Gale could not have committed that murder. But all of that was hidden from the original trial team. So it was when that came out that he got the new trial. It was on that basis that the second jury acquitted him, and it was certainly on that basis that we got out a bunch of money from the SBI agent and from the state. So my recollection is that the son became an advocate once he realized what this agent had done by covering up all that evidence. And that's sort of a hidden part of what goes on in cases where there's prosecutorial or police misconduct. You watch the murderer and you see the vehemence with which the victim's family hates Dassey and Avery, or even in the staircase, you see the vehemence with which Candace hates Michael Peterson and me for that.
Right.
And it's just unfortunate because they're putting their energy and their hatred in a place where it really isn't justified, and it ends up hurting them psychologically and emotionally as well. So it's an unfortunate byproduct. I don't think people really think that much about it, but it's what we will live with.
And one of the things that's disconcerting is I remember in Mr. Peterson's case, there was also an issue where when you guys were talking about the Alford plea, where they said the sisters wouldn't agree to it. His deceased wife's sisters wouldn't agree to it. And, when you start giving these, quote, alleged victims the power and the authority to make decisions, we had that in Robert Blake's case. And Robert Blake, the detectives in that case I had known for many years and had worked with on numerous cases prior to that. And then in the courtroom, I see them hugging family members. And I literally went up to them and said, you can't do that. You simply can't do that. You represent the people of the state of California. And,
yep.
It has to be for the benefit of the people. It's not, you're not their investigators. You're not their personal security team. And when I heard about the sisters having some say in this, I was really sort of surprised, thinking, is that normal?
Well, that's completely political.
Right.
You had a new DA, and he's going to stand for re-election. Actually, he just got defeated recently. But he was a brand new DA. He had just been elected, or perhaps he had been appointed and was running for election. I can't even remember now. But bottom line was that he wasn't going to do anything because, they were squeaky wheels. And if he had done something that upset, particularly Candace, she was going to go screaming to the media, and he was afraid of that. And so you have politics getting in the way of justice, and I think that's really, really unfortunate. And I told him that. I told him I thought it was wrong. I thought, he's not their lawyer; he's the state's lawyer.
Right.
He's the people of Durham's lawyer, and he ought to be thinking about what's best for the people of Durham. And a retrial certainly wasn't in their interest. But like I say, I think it was purely politics and re-election concerns.
Hey, David, we have to take another break, but you brought up something really interesting. And again, can you stay with us?
I can stay with you for a few more minutes. So,
Okay.
We can run for another 5 or 10.
Yeah, we have to take another break because you brought up something interesting. One of the things I want to get into is the new New York law. They've got a team of people that are going to be investigating prosecutorial misconduct. This is All Things PI. We have to take a break. We'll be right back with David Rudolph. Stick with us.
NBC Talk Radio, KCAA 1050 AM.
Hi, my name is Phil Grandy, philsgang.com. Most people would love to be in the stock market, but they're scared not being in. They're scared about not getting out in time. Well, that is over because now you can join Phil's Gang and my stock video program and follow me with specific stock on the video, and you will be out in time.
Find out more at philsgang.com or call 877-600-GANG. That's 877-600-4264. Why pay thousands of dollars for a weekend seminar when for only $39.95 a month? philsgang.com provides all the daily market investing information you need to make profits in the stock market. With over 40 years of investing experience, only Phil Grandy and the philsgang.com team provide daily live investing webinars, up-to-the-minute market updates, all the investing educational videos you can imagine. Don't hesitate to learn, invest, and make profits. Go to philsgang.com or call 877-600-GANG, 877-600-4264.
Are you having trouble sleeping? Are you always tired and worn out? Is it affecting your work and personal life? Well, South Pacific Sleep Lab can help you out. South Pacific Sleep Lab provides a personal study of your sleep patterns. With their trained specialists, they will diagnose your sleep habits and will give you a prognosis for getting a great relaxing night of sleep. South Pacific Sleep Lab has locations throughout Southern California, including Fontana, and will provide transportation to any of their locations at no cost to you. To find out more, give them a call at 844-SAD-5050. That's 844-SAD-5050. South Pacific Sleep Lab. Start resting easy and sleeping sound today.
Okay, we are back. So I just mentioned that briefly. Have you seen that new panel, that new law that was passed in New York?
I have. I'm not familiar with that.
They have passed a law that is now reviewing items like Brady, whether or not the New York state prosecutors are turning over the proper amount of information. And they are sort of reinforcing it now with a review panel that prosecutors can not only be terminated, they can be charged criminally for failure to disclose exculpatory information. And that if you, again, like in your case, if you had filed a complaint, once the blowpoke example in the staircase, once the blowpoke in Michael Peterson's was discovered and the prosecution knew about it and presented this, clearly it was a fabricated theory by bringing in experts, testing this item and what have you, they could actually be terminated. And the sad part is now that particular prosecutor I saw is now a judge. I find that to be mind-boggling. He should have been.
Well, and I don't know that he was ever informed of it. I know that the police found it. I know they photographed it. I know that we never got any of the photographs of that lookbook that were taken back in June of 2002. I don't know whether or not the prosecutor knew about that. But let me also say one of my pet peeves is that prosecutors have absolute immunity from any kind of civil liability.
Right.
And I personally think that that's excessive. I don't think they need absolute immunity. I think that good faith immunity, just like what police officers have, would be more than sufficient. And I think if they didn't have absolute immunity, that might very well deter some of this misconduct that unfortunately does go on among some prosecutors and among some prosecutors' offices. The culture generally flows from the top down, and if you have a DA who's willing to cut corners, what you end up with is an office that's willing to cut corners.
I had a case years ago. The kid was arrested for murder. We were able to prove that he wasn't there based on cell towers, literally within 10 days. He spent 8 months in custody, clearly no comparison to any of the cases you've worked on. And the short version is he was ultimately released. He sued the city of Glendale and received a judgment. But what was most interesting about that is, you're right, we weren't able to incorporate the DA in the lawsuit. But more importantly, he was able to sue the two detectives and got punitive damages to the tune of $75,000 each against the detectives. And I mean, the city of Glendale picked up the tab, but just the fact that he was able to get punitive damages, the police knew he was not involved in the murder. It was a home invasion, and there were 5 people involved. And they came forward after the fact and said, we knew that if we let him out, it would give the other people a false sense of security, which is insane. So they were perfectly content to keep somebody in prison, well, in jail, county jail, for what they decide or determine to be the greater good. And that's not how the Constitution was written, and that's not how it works. And personally, it just aggravates the what out of me.
Well, and I don't think in very many, if any, cases is there an attempt to frame somebody who police know is innocent. Much more common is that they decide, as a matter of their arrogance, that they know who did it, and then tunnel vision kicks in, and so any evidence that is inconsistent with their theory becomes irrelevant or unreliable. And all they focus in on is the evidence that they think is consistent. And then, if they don't quite have enough, then they'll make up some more, because they don't want this person who they're convinced is guilty to get off. And so it becomes ends justifying the means.
And that's it. That's exactly the position that they assume, is that the ends justify the means, and they've already decided the person's guilty, and they completely circumvent the law.
And they're right. I mean, it's a combination of rush to judgment and arrogance about their own ability.
Right.
Lack of humility, we'll put it that way.
What was interesting, again, with going back to the whole Robert Blake nonsense, the defense attorney Harlan Braun was criticized pretty significantly for releasing information on the victim. And interestingly, too, in contrast, I don't know if you remember Kobe Bryant, when he was charged in Colorado, they had rape shield laws, and they started to release information on this girl. And everybody was in support of it. Kobe Bryant's a nice guy. Everybody likes him. Robert Blake, nobody likes. If you know Robert Blake, you don't like him. So it was one of those, again, rush to judgment issues that they decide, and the media gets involved. I was very supportive of your position with who I call Nancy Disgrace and her coverage of Mr. Peterson's trial. Because again, she's just so far out there with her crazy theories, and she gets people going. And the same thing as Scott Peterson. I worked on Scott Peterson's civil case years ago, and the bottom line too is these people just run amok, and you're never going to get a jury that's not following these cases.
Well, and you were talking earlier about the Scottish system of not proven. Similarly in England, there can be no publicity prior to a verdict. So the Nancy Graces of the world simply can't spread their venom in Great Britain prior to or during a trial. Just to get back for a second to the whole not proven verdict. I think, I've thought about it, and I guess it's good that I keep learning even after all these years. I think the next time I have a criminal case, I am going to start talking about not proven as what the verdict really means. Because the words not guilty sort of equate, I think, in jurors' minds, even unconsciously, with innocent. And so I think, I don't know how Tom Messer feels about this, or others, but I think that I am going to start talking about the fact that a not guilty verdict is really a not proven verdict. I've got some charts I use to explain reasonable doubt to a jury, and I think I'm going to start incorporating that whole phraseology not proven into my closing arguments, because I think it's a very powerful psychological concept to explain to a jury that when they say not guilty, they're not implying somebody's innocent. They're simply saying, hey, prosecution, it's not proven. And I think that's something I'm going to incorporate going forward.
There's the judges out here, I can tell you, in Los Angeles County would probably lose body fluid if you tried to start getting into the not proven aspect.
That's okay.
Yeah. Yeah.
You know, maybe they're a little overweight and need to lose a little bit.
There's a judge. I just want to tell you quickly. You'll enjoy this. There's a judge in Los Angeles County in Inglewood. His name is Victor Wright, and Judge Wright takes the position. He tells the jurors after they've been sworn in that the defendant is not on trial. The prosecution's case is on trial, and you know, that is just such an amazingly fabulous statement to make, but he's the only judge that I've ever heard say that, and it's true. What he's saying is gospel. But that's, you know, it's not how it's dealt with. Do you remember? You remember, of course, Casey Anthony. There's a classic example of the young woman who was accused of killing her 4-year-old daughter, Casey Anthony. You know, the jurors came back when they acquitted her. The jurors came back and they were getting death threats. And that's just completely ridiculous, simply based on the fact that, you know, how could you say she was not guilty? And exactly as you just said, that's not what they were saying. They were saying the case wasn't proven. Well, go ahead.
You know, at the risk of raising the judge's ire, although, you know, as you get older and more experienced, judges seem to let you get away with more than when you were younger. So maybe they won't yell at me quite as much as they would have. But I'm gonna certainly try to work that into my argument, and even into my jury selection, for that matter. You know, I think working that idea into voir dire is probably something that we all ought to be thinking about.
Yeah, I completely agree. And for those who don't know what voir dire is, that's the process of vetting essentially the jurors to discuss the prejudices and knowledge that they may have previous of the crime, or the charges, I should say. I have a quick question. I got a text from a seasoned detective whom I know personally. Wanted me to ask you a question. It says, the inequity between the first responder's observation of the blood and the 911 call saying she's still breathing. He had a question about that, and he has watched my representation. I had him watch the show, and he was head of detectives, I can tell you, for a city out here in LA County. But he's trying to look for an explanation of the dried blood. Do you have any thoughts on that?
Yeah, I do, because it didn't appear in any of the initial reporting of the crime scene. That whole idea really arose after the fact, and it became sort of a central theme of the prosecution. But in fact, when Kathleen Peterson's body was lifted up and taken out of the house, it was still dripping blood. There was still blood pooled underneath there, and you know, the blood. No one was really focused on how, quote, dry, or at least the EMTs weren't focused on that. You know, at the time that they were rushing into the house, that's not what they were looking at. Now, you know, by the time Deaver got there several hours later, was there thin smears of blood that had dried by that point? I'm sure that's right. But that whole concept really wasn't terribly trustworthy, although obviously the EMTs were a part of the team by the time the trial came around.
And see, one of the things as far as the smears on the wall, that could have been her, because again, I had a similar case. That could have been her just trying to get up. She could have been smearing it herself.
No, absolutely. No, that was our theory, because she had blood on the bottoms of her feet. I mean, not just a little bit, but the entire bottoms of each foot was covered in dried blood.
Right.
When you look at the autopsy photos, that could only happen if she was unconscious for a period of time and then stood bleeding and then stood up in a pool of blood. You're not going to get a full footprint of blood on the bottom of your soles just during an attack. So I think everyone agreed, even the prosecution agreed, that she had lost consciousness for some period of time, and then stood up. Indeed, in his closing argument, Jim Harden argued that that's when the premeditation occurred. After she had come back to consciousness, that he then attacked her again, and that's when the premeditation necessary for first-degree murder actually was formed. So that was their theory. And indeed, what was important about that is that Dwayne Deaver was the person who gave them that theory. They relied on Dwayne Deaver to argue that. And so it was Dwayne Deaver who was the only evidence that the prosecution had on first degree.
The other thing that I remember seeing that I thought was sort of interesting is there was no indication as to the temperature of inside the house, because that was my response when this detective friend of mine asked me about that. I said, first of all, I'm not familiar with North Carolina, but it's December 9th in North Carolina. Just because they're outside doesn't mean that it's not cold, and it doesn't mean that the heater wasn't going on in the house. And again, without having taken that ambient temperature, that could have caused some of the drying as well.
Well, there's lots of factors that go into blood drying, as you probably well know.
Right.
One of which is how much blood is there. If it's a very thin smear, that's going to dry much more quickly than a puddle of blood or a pool of blood. So you have to, and then of course things like temperature, humidity in the house,
right.
Airflow, all of those things affect the drying time of blood. So, and indeed, if she was unconscious for some period of time, some of the blood may very well have dried while she was unconscious.
Sure.
So I appreciate the question, but I don't think it proves as much as the prosecution would have it prove.
The other issue, too, that I remember, it wasn't until, I believe, the final episode that there was even any conversation. And frankly, that was your conversation as to trying to surmise the cause of death, because there was never any actual I didn't read the autopsy, obviously, but there was actually no cause of death. I surmised that she had bled out, and that's pretty much what you came up with, or said, I should say.
No, well, what was interesting is that the cause of death on the autopsy was blunt force trauma.
Interesting.
What we found afterwards was a note that Fred Black, the prosecutor, had written that Deborah Radish had told her that she had originally put exsanguination, blood loss, as the cause of death, and that the chief medical examiner, John Butts, had forced her to replace that with blunt force trauma. Now, I never heard anything about any of that during the trial, obviously. It was just a handwritten note that we found going back through the file in preparation for the hearing in 2011. But the reality is that there was no injury to her skull or brain that would have caused death. So to say the cause of death was blunt force trauma was completely misleading. There was no dispute at any point. She died from exsanguination. She died from blood loss. That was the cause of death. No one really disputed that. Indeed, the medical examiner admitted that during cross-examination.
And in Phil Spector's trial, the original autopsy indicated it was a self-inflicted gun wound. And again, the prosecution stepped in and had that changed. And there was a second autopsy. I don't know if you're familiar with it. I'm sure you didn't follow Spector's trial. But again, that was the causation for the hung jury the first time around, is that when the prosecution steps in and starts changing these things, which they are known to do. I've always been bothered by the fact that the investigating officer will attend the autopsy because they have an ability to sit there and discuss with the medical examiner things that they want to look for, with specificity, or start asking questions. And again, it's entirely discretionary whether they document or don't document these things. And I've always found that to be problematic. Do they do that there? Do the investigating officers?
Yes. The investigating officer is virtually always present at an autopsy, and I completely agree with you that it's rife with the opportunity to create essentially misleading evidence.
Sure. And that really, I don't think, started happening in Los Angeles. Again, I've been doing this close to 40 years, and that didn't actually start happening in Los Angeles till about 20-25 years ago. That was not the way that things were conducted.
Well, in North Carolina, we had a medical examiner when I started in 1978 named Paige Hudson, and he actually viewed the medical examiner's office as a separate, independent agency. And he really didn't care what the officers said. That after he retired, that unfortunately changed. I was sort of hoping that would become the culture of that office, but it hasn't.
Yeah, and as was so aptly pointed out in the staircase, is that these alleged experts are supposed to be testifying to the scientific aspect. They're not supposed to be formulating an opinion one way or the other.
Yep.
Yeah.
Well, that was their bias was sort of aptly summed up by one of the lab tech's little victory dance after Deaver was able to finally get the blood spatter to go inside the shores after multiple attempts.
Yeah, that was nothing short of disgusting. I remember seeing that, thinking, what are they thinking? Again, this is about scientific issue. I can go on and on about cases I've had. We unfortunately have to take another break, David. I really appreciate your time. You are totally welcome to stay, but if you got things to do, feel free.
I'm sitting here in Massachusetts on the shore. It's a beautiful day, and although I really enjoy talking with you, my wife and daughter would really like my company back. So I'm gonna pass on the opportunity, but I really appreciate your speaking with me. It was a good conversation.
And I got to tell you, I absolutely am very impressed by your work, and keep it up. Really, God bless you. I appreciate it. Okay, thanks. All right, we'll be back in a few. Again, you're listening to All Things PI with Scott Ross. Thank you.
NBC Talk Radio, KCAA 1050 AM.
Are you having trouble sleeping? Are you always tired and worn out? Is it affecting your work and personal life? Well, South Pacific Sleep Lab can help you out. South Pacific Sleep Lab provides a personal study of your sleep patterns. With their trained specialists, they will diagnose your sleep habits and will give you a prognosis for getting a great relaxing night of sleep. South Pacific Sleep Lab has locations throughout Southern California, including Fontana, and will provide transportation to any of their locations at no cost to you. To find out more, give them a call at 844-SAD-5050. That's 844-SAD-5050. South Pacific Sleep Lab. Start resting easy and sleeping sound today.
Hi, my name is Phil Grandy, philsgang.com. Most people would love to be in the stock market, but they're scared not being in. They're scared about not getting out in time. Well, that is over, because now you can join Phil's Gang and my stock video program and follow me with specific stock on the video, and you will be out in time.
Find out more at philsgang.com or call 877-600-GANG. That's 877-600-4264. Why pay thousands of dollars for a weekend seminar when for only $39.95 a month, philsgang.com provides all the daily market investing information you need to make profits in the stock market. With over 40 years of investing experience, only Phil Grandy and the philsgang.com team provide daily live investing webinars, up-to-the-minute market updates, all the investing educational videos you can imagine. Don't hesitate to learn, invest, and make profits. Go to philsgang.com or call 877-600-GANG, 877-600-4264.
Okay, we're back. Hi, this is Scott Ross. You're listening to All Things PI. We just had David Rudolph. What an amazing attorney. Again, I've worked with some of the best, and I got to tell you, sitting here looking back at some of his work, and you know, you don't always win everything, and no matter how hard you try, but in order for him to sort of keep up with that, and one of the things, again, that we didn't really get to expand on, but this show, The Staircase, I hope everybody gets a chance to watch it. It's on Netflix, and it really is a very incredibly accurate, although because of time it's not complete, but it's a very accurate depiction of the defense and the defense investigation, how things unfold. And it's also an accurate depiction, and since it wasn't pre-staged, it's also an accurate depiction of the prosecution and what they do and how they do it. And I don't want to say anything bad about anybody, but again, if you watch the show, you'll see that they thought the weapon of choice was a what's called a blowpoke. I am not familiar with it, but it's a hollow brass tube used to move around fire, and you can blow through it to sort of keep the fire going. It's probably not very predominant in Los Angeles, since it doesn't really get cold enough to have that many fires in LA. But back east, I guess they're well known. And the fact remains that this device was a gift from a family member. And when it wasn't seen in photographs, the family member contacted the prosecution. The prosecution was trying to locate something that would have caused the type of injury, and they determined that this was the device. Although in the middle of the trial, the Peterson family, Mike Peterson's family, actually found the alleged missing blowpoke, and the prosecution did this entire dog and pony show about the blowpoke and how it was the weapon of choice, and all of a sudden they have it. They found it. Everybody had to acknowledge that it was identical to the rest of those, the ones that the entire family had been given. And rather than backpedal, all they said is, okay, yeah, so it's there. Turns out after the fact that they knew it was there the entire time. So again, you're watching what I consider to be a gross misrepresentation of the truth. And again, it's all about winning. It had really nothing to do with the reality of it. And, you know, again, this is, if you've ever had anybody that's been wrongfully convicted, and I get that some people charged with crimes are guilty, believe me, but people that are wrongfully convicted, those are the people that are the hardest ones to represent, because you know they didn't do it. You know they weren't responsible for something. And, you know, again, you're sitting there, you're literally pounding your head against the pavement trying to prove that these people just simply didn't do this. And when I sit here and I look at this history of Mr. Rudolph's, this amazing list of cases of how many times he's prevailed, it's just mind-boggling. And it's not the fact that he prevails in this. What's disturbing mostly is the fact that these cases exist. You can't prevail if they don't exist. You can't win $1 million plus judgments if these people are being convicted properly, if these people are actually guilty of a crime, and if the prosecution actually follows the rules and follows the law, things that were set down to protect us. And not only to protect us, there have been prosecutors and judges that have been charged with crimes in the past, and those rules are there to protect them as well. And when you start to mess around with those laws and you start to change those rules, and you make judgments based on emotional instead of legal reasoning, all you're doing is creating irreparable damage to the system. And again, I want to publicly thank Dave Rudolph for joining us today. I hope everybody can watch the show. I hope everybody really appreciates the type of work that defense attorneys do and the purpose they serve. And again, I hope that nobody ever gets caught up into that situation where they have to go out and find somebody to defend themselves. You are listening to All Things PI. We will be back next week, same time, 9 o'clock a.m., KCAA Radio. This will be posted on KCAA Radio, the audio, hopefully soon. And if you have any questions, you can contact me directly.
KCAA Loma Linda, 1050 AM, 106.5 FM.